Oh, hang on, let me. You've been unmuted. Hi, Karl.
Hey, how you doing?
Okay, thanks.
Good, Karl. How you doing?
Not too bad. What's your name?
My name's Mike. Mike.
Hey, how you doing, Mike? Yeah.
You got a terrible connection, Karl.
I do.
Yeah.
Hey. All right. Maybe we'll walk out a little bit further from the garage. Does that sound a little bit better?
I can hear you just fine.
Okay, go ahead.
Yeah, I got an easy question for you. You said that you were making a claim that you were the owner of the house?
Yeah.
Okay. Now, you said you're still paying the mortgage?
That is correct.
Okay, and this is what I try to explain to people a lot of times. If you look at a pyramid, the owner is like at the bottom of the pyramid, the lien holder is in the middle, and the person who creates the title is above everybody.
Correct.
Right. So what I'm trying to say is, who would have been trying to fight you for ownership of the house? Like, who was fighting for the bottom?
Nobody, because that particular entity no longer had any interest in the property.
Right. So right now you're just dealing with a mortgage company who believes that they have the ability to lien you if you don't pay your mortgage.
That is correct. There's an outstanding note, and we didn't fight the note. We didn't argue. We didn't even bring that up as the issue.
What I'm trying to say is, what was the purpose of proving that you're the owner?
Well, you're quieting title to quiet all claims against the property.
Not the lien holder. You still make what I'm saying. The mortgage company still is making a claim that you owe the debt.
Correct. But here's the difference. If you have a deed of trust on your title of the house, has not been transferred or perfected to the whoever lien holder may be, that is the issue. That's the only thing we're fighting.
Oh, okay. Because like I said, it sounded pretty simple. Like I always say to people, if you look at a pyramid, people can own all kinds of things. It doesn't matter what they own. Like I especially do with my sister and my family, I recommend to everybody all the time, if you're afraid that you're going to be, a paycheck's going to be garnished, or you're going to be lien, to become the owner of your car, of your motorcycle, and be the owner of your property, but let somebody that you trust lien you up. But it's that way when anybody else tries to come and get a garnishment or lien against you, and they try to come in with a deputy or the sheriff's department and try to levy you, remove the property, you say, whoa, 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 whoa. First you have to get that
remove that lien, satisfy that lien. That is correct.
Right. And what I told the deputies, I said, she's not going to be able to satisfy me for another 3 lifetimes. So what's the lien you got on her? Got $500? Oh, just hand it to me. Thank you, sir. Thank you. And you want to help me levy her now? Fine. Take all her stuff and stick it in the driveway, and I'll take care of it.
I haven't thought of using that tactic, but
was it?
Yeah.
Well, don't worry about that. You don't, because like I said, when I went to motor vehicles, I transferred all the property into me being the lien holder for my property, and vice versa with me and my sister whenever we think somebody's in trouble. So when the lady motor vehicles didn't even know, so I said to the lady motor vehicles, I said, look, my sister doesn't believe me. She's the owner, I'm the lien holder, tell her where the title's going to go. She said it's going to go to owner. I said, oh, it's going to go to lien holder. But even the folks at motor vehicles thought that the title went to the owner.
That's correct. I just wish the banks would treat real estate lending as car companies do with lending on cars, because they actually keep the title.
But what I say to folks is, why would you even want a title? Because whoever gives you the title can remove the title at will. So who would even want the title?
Well, part of quieting title on a property is the fact that you're making marketable title for the house.
Oh yeah.
So even though you have a lien holder, you may have a lien holder that is just sitting there idle, doesn't even have any interest in the property. You can't sell that house until that lien holder is satisfied.
In the commercial 2-dimensional world, so that's a wonderful process.
That's
exactly
correct. And unfortunately, with the invention of this mortgage electronic registration system, all of these notes have basically vanished. In my they've basically been shredded, and they only exist as a number in a spreadsheet or in some sort of a database. And so this this notion that there's an actual owner of a note has to be established with actual proof.
Right. Well, that's what I try to help folks. I try to help them understand that what you're trying to do is more than a two-dimensional world where you're trying to work and coincide with the commercial end as an aspect of the profit.
That's correct.
But nobody ever disputed you were the owner. But like I say to folks too, if you watch, like say, just that simple Queen Elizabeth movie, and you see that Sir Walter Raleigh was given all kinds of titles because he was satisfying her, satisfying. And then all of a sudden, she found out he two-timed her, so she stripped him of all his land. Right. And then when she needed him when the Spanish Armada was coming, all of a sudden, he gets his titles again. So I said, why do you people fight for the titles? But you gave a good answer by saying, you want to work in a commercial world, that's what you have to establish.
That's correct.
When you want credit through the two-dimensional commercial world.
That is correct, yes.
So yeah, you did fine, man. I was ready to bash you because no, you did good.
Yeah, well, I'm trying to stay in and use the law to my advantage and not the bank's advantage. And the more you give them to jump over and stumble on, I think the more better it is that they know that people are starting to wake up, fight back.
But what I'm saying, the only thing I could say, instead of spending $50,000 on having an attorney do it for you, like Angela said about John Stewart, he was like, wait a second, there's basically no value attached to this title, just filing a small claims court, because believe it or not, nobody on the other side, other than a man or woman, is ever going to come in the court, or maybe an Indian tribe is going to come and say, well, we're the true possessors of that land.
Well,
other than that, nobody else is really going to come forward.
Well, I'm not an attorney to be able to advise folks on how to go about doing it. I just did it the best way that I thought I should proceed.
Oh yeah, I think if they
like
follow
I said, it's not a finished ordeal. This is kind of like round one.
I think if they follow your the way that you or your attorney submitted it for publication, I read everything. It was 34 pages when they came back with that the securitization audit. This was 34 pages. And I didn't read it all, but I liked the way they did the publication, and then they tried to go in for the demur, and then they said that you changed the original complaint so that the demur was denied, because you had just submitted a new complaint, new claim. So yeah, I read it really quick. I read it really quick today, but like I said, what I think folks should really pick up on is the way they did the publication, because that is such a huge asset, where it's really not, it'll take a lot of study for folks to just read that part and know how you make notice to the world, especially at the commercial level.
That's correct. And the banks give you notice when they're going to come take your house.
Oh yeah.
Quiet title basically is it requires the same, that you have to give notice when.
And they have to give you notice of what? Before they give you notice of foreclosure, they have to give you notice of acceleration of the debt.
That's true. Yes.
That is a great loophole to catch them in, because they always forget.
That is true. Yes. That's
Somebody,
kind of step one for the bank. Yes.
Somebody on the chat here is asking, let's see, Bondi 3342 is asking, what happens when they send you back the deed of trust after closing? What are they using to secure your property then? I don't understand it.
I'm sorry, I'm not sure I understand this.
I don't understand it either. They sent you the deed of trust. What happens when they send you back the deed of trust after closing? What are they using to secure properties then? I don't get it.
I'm not sure I understand the question, but I think...
They sent them back the original deed of trust after closing.
Did they pay cash?
I'm not sure. There isn't a sale occurring here.
Secure the lien. I don't know, Bondi, why don't you dial in and ask? It would be better than trying to read it off the chat here. It's not coming through very clearly for us. Anyway. No, I did not pay cash.
I wanted him to be my friend.
Well, one of the things about obtaining a quiet title judgment is it allows you the flexibility to take action in other ways. So
We can barely hear you.
one of the things that obtaining a quiet title judgment, it allows you to go back in and petition the court to take action against whatever liens may be recorded on the property to have those expunged. So it's not just like you get quiet title and then, you know, this is not a free and clear house kind of thing. That's not what I'm not here to say that, hey, you can do a quiet title and get your house free and clear. That would be false. You first of all have to fight tooth and nail with the bank that actually wants to take the house. So you have to take that into account because they have more money, more resources. I didn't quiet title to try to get a free house. That's not my objective. My main objective is to try to make some case precedent here for folks to be able to kind of catch on and learn of how to protect their property. And if they can negotiate some sort of settlement with the lender at that time, that would be good. If they can get a free house, that'd be great too. But you know, unfortunately, these days they got more money than we do. You have to. If you don't mind, like I said, what you're doing is great for, like you said, in the commercial aspect, and the credit card rating and credit card debt. That kind of stuff makes a lot of sense. But I try to get people, if they really want to have their place free and clear, you do the allodial. You want to get your property be, you know, noticed to the world as in a allodial state. You know, you don't want any titles attached to it. Okay. Because of the state of California, it gives you a title. If they give you the quiet title, then they're still saying, like the Queen of England, she could strip you of your title. So I don't want any titles of any type, but what you're saying, a title is good if you want to work in a commercial aspect, in the commercial world, then that is an asset, and it shows that you are, you know, in the two-dimension and that you have a good credit rating and everything else. Right. But I try to say to people, I think what people get confused when they hear your stuff is they think they're going to get everything free and clear, and now their property and land is all theirs, and they can do whatever they want with it. And no, it's not.
Okay, but wait a minute. You're dealing with a second, right, Mike?
No, there is no second.
Oh, I thought there was another lender involved in
Initially there was, and as part of the process, that second was contesting my quiet title. And since it was such a small amount, and I didn't want it to interfere with the case, so therefore we dismissed it. And eventually I ended up having a settlement attorney settle that out.
I see. Okay, so
all I was trying to help folks with Angelo is to show them that his property is not now in a allodial state. It doesn't mean that anybody still can't make claim or lien him or strip him of his title. But he's got a good game plan going for the commercial world.
Okay. Bondi here is saying that the recorder's office sent me back the original note, the wedding signature note that they signed. And they sent the title company back a copy of the original. So if they have the original, no one can really foreclose on them, right?
In theory, yes. But as you've seen in Florida, you've probably seen some of these videos of folks being foreclosed on and the house has already been paid off.
Oh, yeah, and they're foreclosing on people that aren't even in foreclosure for crying out loud.
They're foreclosing on the wrong house.
Yeah.
Angela, what would happen is the bank or whoever's holding the mortgage, what they would do is they'd follow Rule 60A on that woman and say, due to a clerical error or act of omission by the clerk, this paper wound up in the wrong hands. So they just do a Rule 60A on her.
Oh, there's your answer, Bondi.
But it's cute.
Yeah, in California we have what are called APN numbers. As long as that parcel or that piece of property has an APN number and some sort of a tax assessor's ID number, I'm pretty sure that it can be leased.
What can?
Property.
Oh, okay, but your property, I don't understand. I thought you had your house free and clear now.
It's not free and clear, no.
Okay, so then
he has better standing in court, Angela. He's got better standing in court now, and he's
for
on his credit rating. His credit rating could go up. It's all commercial, what he's doing. It's all for the business.
Right? Is that what you're going for here, or
Well,
what?
like I said, this whole process is not finished, and we're almost getting into the tail end of it.
Okay.
And there's certain things that I cannot disclose about it.
You know, I look at the paperwork, and it looks to me like you won.
I did, yes. I won the judgment, which allows me to do other things now,
Okay.
take other action. And unfortunately, because there's still things pending up in the air. Like I said, in about 3 months, if you want to call me back, I can give you a final update of where things are.
Okay.
But as far as the outlook, I intend to keep these banks in check.
Well, yeah, I mean, if they don't have the paperwork, they don't have the right paperwork, and they don't have standing to foreclose on you, screw them.
Yeah, well, the main thing is that somebody has to be able to make a stand and show the public that just as easily as they can come in and kick you out of your house, it's as easy. It should be as easy to displace them from rights from your property.
Right. I agree.
And if you bring that into a court setting, then the law has to be applied based on the happening, the reality of the world. There's no interest, that there's no liens, there's no mortgages recorded, that there's nothing. And they have to kind of explain and come in with proof now. So it makes it a little bit more difficult for them.
Especially knowing that you can foreclose.
Especially knowing that this note has been securitized and shredded and basically gambled away.
Yeah, well, they can't come back with any paperwork then, can they? They can't prove anything. Huh?
Well,
they could foreclose on him.
Yeah, they could, but they need to come in with some hard proof.
They could still foreclose on the man, so this didn't negate the fact that he still owes a debt. He's still working on it, he said.
Right,
Maybe
right.
Get lucky.
So they
Maybe
could
get
still
lucky.
yeah. Well, if they did the securitization audit and show there's a break in the chain, they're not really a party to it because the original lender, right, is who.
Yeah, the original lender has been paid off. They're gone.
Right.
They're no longer in the picture. That's what I'm trying to say.
And they're the only ones that had the right to foreclose, right?
That is correct. In theory, yes. But due to the securitization and how the notes and whatnot have been securitized, and you have MERS involved, as I'm sure everybody's familiar with this shell, basically a company that is propped up by the bank, owned by the bank, created to keep track of these mortgages that people supposedly own or owe on these properties. These mortgages are stored in this database, and the activity is monitored by the banks. The banks are the members of MERS. They go in there and they can change and update, reassign, and move these notes to other servicers. And there's no actual hard copy document, at least that I'm aware of, because generally, in my view, what happened with MERS is it was actually established as a way to be able to facilitate moving these notes into Wall Street and tracking them that way. Now you have the collection arm of it, where the banks are taking care of all the services. And the sole purpose, I think, of that database is mainly used to be able to track and be able to foreclose, send information, address, phone, or person's name, social security number, all this pertinent information to the person that owes on it, so that they can come and foreclose on it. And most of the banks these days are just basically taking the information that's in there and drafting all these documents, foreclosure mills or robo-signers, and creating false assignments, recording them in land records and using that as case, as something to take you out of the house.
It's illegal to do that, though. That's a criminal act.
It's like, I believe before the call, we were talking about Congressman Alan Grace. He's got a great video.
You need to speak up a little louder, Mike.
Okay, can you hear me now?
Yeah.
Sound like I'm a commercial here. Like previous to the call, we talked about the video from Congressman Alan Grayson. I think he released it in September of 2010. He points out a lot of things that are so important as to what has happened from, the banks and how they've behaved against homeowners, all this fraud, all this creation of documents, foreclosing on homes with fabricated documents. And finally, I guess the judges are starting to pick up that it has been happening, and some folks are, they've been getting their house, I guess, free and clear here and there, but that's because of the bank that comes in with phony documents trying to bring fraud on the court.
Right. You can't let them get away with it.
No, and it's still, I believe, in my view, it's still happening. And just a lot of people are not aware or do not know how to identify if something is being created from thin air to be able to file and record at the county recorders, and that proves that basically gives you notice that constitutes a foreclosure in law. When all that is, these documents are not self-authenticated. They weren't drafted, with original documents. They weren't maintained. Notes weren't transferred properly. So there's a whole string of problems that are connected to what happens with your notes, to what happens with your deed of trust or mortgage. It's a total disconnection.
So, what's your next step? Are you going to try to? Yeah, are you going to try to prove there is no mortgage, but it's been satisfied when you signed it? What's your next step? What's your next game plan?
My next game plan is actually already in effect. I would have to give you another update at some point.
Okay, we won't go into that.
But I can't bring it up into this, right now into this conversation because it's still fresh, and I don't know who's listening, and it could potentially.
Yeah, you don't want to tip your hand or anything like that, right? Oh, if anybody has a question, press star 8. Over 100 people on this call, so it's, can you hear the dog barking in my neighbor's yard? Gosh, never fails. Okay, we have some questions for you, Mike. You ready for some questions?
Yeah.
Karl, I'm going to go ahead and mute you out. Are you, if you have anything else to say, just put your hand up, okay?
All right, thanks a lot, Ange. Have a good night,
Thank
Mike.
you.
No problem. Thank you, Karl.
Goodbye.